The views and opinions expressed in this podcast are simply that, opinions. All are presumed innocent until proven otherwise in a court of law. Sensitive topics are discussed. Discretion is advised.
Trinity Pogue resented this child.
No evidence about a crime occurring at all. In other words, you'll see no blood evidence, you'll see no DNA evidence, you'll see no spittle evidence, you'll see no throw-up evidence.
Who was Romeo Angeles?
It's my son. She gave him some Mountain Dew and like a Frito Dorito. It's Frito, like the barbecue twisted chips.
Okay.
And he was sitting there eating them. She had him in her hands. It's like he's limp. I don't know what happened. So I threw the pizza, dropped it, and grabbed him and took off.
A former pageant queen is accused of killing her boyfriend's baby. The father of the victim takes the stand. Could he be responsible for little JD's death? Plus, we're taking a closer look at the former pageant queen. We've got a body language expert coming on the show to break down her demeanor in the courtroom. And how to dismember a body. Very disturbing internet searches in the murder trial of Brian Walshe. So we're asking, has the Commonwealth already won the case? Plus, Luigi Mangione's motions hearing, the evidence against the accused assassin. His lawyers working hard to keep it out of his trial. Will they be successful? It's all coming up next for you right here on Opening Statements. Good Wednesday morning to you and welcome to Opening Statements. I'm Julie Grant. Are you ready for some coffee and some court? It's that time where we get you all warmed up and ready to go for the big day ahead on Court TV Live. So let's grab a cup of coffee right now together. It's time for my opening statement. He didn't stand a chance. Precious little angel baby Jackson, you'll hear him referred to as JD in the courtroom, didn't stand a chance, sadly. This precious child deserved so much better than what he experienced in the 18 months that he was on this earth. I wanted to scream when I heard that his father and his beauty queen defendant girlfriend were feeding that baby barbecue Fritos and putting Mountain Dew in his baby bottle. What's wrong with them? You don't give a baby Mountain Dew and Fritos. They fed him vending machine food. It's really messed up. What's more, babies don't belong in college dorm rooms. Babies belong in safe places with people who love them. Sadly, I don't know that Jackson was always loved when he was with the adults who were taking care of him. I hope he was. His mom went off to Mexico. His dad sort of took care of him, but with lots and lots of help, we know, from both his sister and from the pageant queen girlfriend defendant. But Miss Congeniality resented baby Jackson, according to the state of Georgia. She was 18. He wasn't her child, and she didn't like having to be his babysitter. Beautiful baby Jackson didn't stand a chance because he really couldn't count on anybody 100%. That child got passed around and was arguably neglected before the incident in question, according to the case evidence. How I wish we could get this precious baby back. But all we can really do is hope and pray that the person or persons responsible for that innocent baby's death are held accountable. That's my opening statement on this Wednesday morning. Let me know if you like it. Right now, it's time for your daily docket.
And you went into the room. What happened when you went in the room?
She had him in her hands. It's like he's limp. I don't know what happened. So I threw the pizza, dropped it, and grabbed him and took off.
The case I was just talking about, the murder trial for defendant Trinity Pogue, resumes at 9 a.m. Eastern. In Kansas, we've got the sentencing for defendant Joseph Schorer. He pleaded no contest to aggravated child endangerment in connection to the investigation of his missing adopted daughter, Natalie Garcia. His wife was already sentenced for torturing and killing the 6-year-old, confessing to burying her in the backyard. Court's going to get underway at noon Eastern. And in Florida, we've got the sentencing expected for defendant Daniel Stearns. He's facing up to life in prison for the murder of his girlfriend, Nancy Howery. Her remains were buried, dismembered, and scattered. Court's going to get underway at 3 p.m. Eastern Time. Right now, we turn to your top story this morning. The Commonwealth's case rolls on in Massachusetts in the murder trial of Brian Walshe. His chilling internet searches are what took center stage on Tuesday. Testimony resuming in less than an hour from now. Court TV crime and justice correspondent Matt Johnson has more.
Julie, good morning. Today, Trooper Garino will take the stand once again to finish his testimony and answer more questions about those disturbing internet searches.
What is the title on page 730, record 2626?
Hacksaw, the best tool for dismembering a body. Can you be charged with murder without a body? Google search. Disposing of a body in the trash. Google search.
On Tuesday, the jury heard from investigators who analyzed the devices taken from the Walshe home. They were also shown pictures of cuts to the defendant's hand and heard more recorded interviews where Brian Walshe blamed his 6-year-old son for some of those disturbing internet searches.
How do you explain at 4:54 in the morning, the iPad is querying the 10 best ways to dispose of the human body?
Thomas is in his room with the iPad. Thomas is usually, I don't use that iPad.
The searches that you were asking Mr. Walshe about at that time, those searches were not, in fact, conducted on the mini iPad that was associated with his son, correct?
Yes, they were synced to that, but they did not occur on that iPad, is my understanding.
He never used his young son's mini iPad to conduct any of those searches that we've heard about, correct?
Correct.
And Julie, still no word from the defense if Brian Walshe intends to testify. But if he does, he'll be asked about those disturbing internet searches on the stand. That's the very latest from Dedham. I'll send it back to you, Julie.
All right, thanks to Matt Johnson for that early update. So let's talk about how does Brian Walshe's defense team handle those very incriminating web searches? Let's bring in criminal defense attorney and former prosecutor Franz Borgard and law enforcement expert and trial consultant Sonny Slaughter. Good morning to you both. So what does the defense team do about these searches? Is there any way around this? Franz, would you start us off, please?
I think the tactic will be, Julie, that they're going to lean in, and I mean he's pled guilty, has he not, to getting rid of the body? He's pled guilty to the disposal part of the case. So I get that the theory at one point was, well, maybe it was somebody else searching for dismemberment, but I think he just needs to lean in and say, well, yeah, I searched this. Because ultimately I did get rid of the body, but it doesn't mean I killed her. The problem's going to be the proximity of time of those searches. When did the searches happen? Did they happen before she died? Did they happen after she died? If it happened before she died, then they've got to point the finger at somebody else, Julie.
Right, Franz. Good point. So let's take a look at something that was searched before Anna Walshe's death. So the cell phone expert testified that Brian Walshe was searching for some pornography days before his wife's death, and apparently he knew she was cheating as well.
Cheating wife seduces another man to impregnate her. Scarlet Scandal, Seth Gamble, Erotica X, Pornhub.com.
And you don't know how long this person that was looking at this movie, how long they viewed the movie, or if they viewed it at all.
I do. It shows me a time frame of 7 minutes.
Okay, so that was a little bit on cross there. Sonny, your thoughts on these searches? How damning is this evidence when it comes to the homicide charge?
Good morning, Julie and Franz. Thank you for having me, as always. So I think this information is damning, but as Franz said, he's already pled guilty to disposing of the body. But from a law enforcement's perspective, this makes him and made him the immediate target unless he could say someone else was in the home. Does it make plausible sense that the 6-year-old would do these searches and use this particular language? And does it connect him to the homicide? Unless there's someone else there, unless there's a reason for someone else to search these, this just makes it closer in proximity and time. Even if he did it months before, that he was thinking about this, that this was a consideration, and that he's the person that did it, which is why he was the target so quickly.
Right, Sonny. For me, the searches do incriminate him on the homicide because they show his consciousness of guilt. I want to play another clip. This is where his web search of the trash bag killer, Patrick Kearney, comes into case evidence. Let's take a look at this.
Patrick Kearney, Wikipedia.
And could you please tell me the date and time for that?
Yes, January 1st, 2023, 11:30:57 a.m.
And what did you learn?
That Patrick Kearney was called the trash bag killer.
Okay, and we know that there were trash bags that he disposed of in dumpsters that police believe contained Anna Walshe's remains. Franz, let's look at this from the prosecution standpoint. I think they have a great case. I really do. I think that he is so foolish to try, but it's his right. He's presumed innocent. It's up to the Commonwealth to prove his guilt beyond a reasonable doubt. Tell me what you think about the point I just raised about those searches indicating his consciousness of guilt.
So if it's disposal searches, we're talking about, absolutely. Looking at the pornography, I don't know that if I were a prosecutor, I would really be leaning too far into that, because my fear would be, Julie, I don't want a juror who occasionally looks at pornography, which is not a crime, saying to themselves, well, are you trying to say that if you look at pornography that, you're a murderer? I mean, that gets down rabbit holes you don't need to go down. But any searches for disposal of a body, any searches about other murderers, absolutely, in conjunction with the fact that he's already pled guilty to getting rid of the body, which, lest we go without saying this at least once today, we don't get rid of the bodies of those we love simultaneously to say that we didn't kill them. If we discover someone we love who's deceased, we generally call 911.
Exactly.
So that is, to me, the circumstantial evidence is so overwhelming. He's got big problems.
Oh, exactly, my friend. It defies all logic to think that, you make the giant leap from, oh my gosh, my spouse is dead in the bed, my goodness, to let me carry her down to the basement, dismember her, go buy cleaning supplies, enough for the whole neighborhood, cut up her body, dispose of it around the city where we live, and lie about it. You don't do that. Unless you want your spouse dead, right? Sonny, tell me, I want to tap into your jury consulting experience. So I'm wondering what these jurors are thinking. I wouldn't be able to stand the sight of him if I'm on that jury. It's a good thing I'm not on that jury. Tell me, for his sake, anyway, tell me, Sonny, what do you think they're thinking? Do you think they have some minds made up already?
Julie, I've been thinking about this, and as a jury consultant, they absolutely have their minds made up. They are looking at their own lives and their own experiences, which is what we ask jurors to do, to bring yourself to the table and your experiences. And what would they do if someone that they claim to love was in this predicament? Do they have their minds made up? Absolutely. Are they paying very close attention to what is going on? Absolutely, because they will still have to decide whether the charge meets the evidence, and they still have to look at it. They still have a job to do. I'm confident that they will do it, but just like you, I could never be on this jury because I would probably be thrown out saying, okay, we're done with the case. We can move on, and let's just go straight to the sentencing for him.
Right. Sonny, Franz, excellent points from you both. Stand by. We got more cues for you, please. We're going to hit a break. When we come back, here's what's coming up for you here on Opening Statements.
The issue of this United Healthcare CEO being shot is so large and touches so many Americans that I think it's almost impossible to find someone who would be unbiased and could just hear the evidence in the courtroom. You'd have to be living under a rock and have never had anyone who was ever affected by the healthcare system ever in your life, and that's impossible.
Accused assassin Luigi Mangione in court this week, trying to keep some key evidence against him out of his trial. Plus, what does the jury think about former pageant queen Trinity Pogue? We're taking a look at her demeanor in the courtroom with a body language expert.
The Court TV podcast will return.
As soon as he was wearing a blue medical mask. As soon as we pulled that down, or we asked him to pull it down, me and my partner and I recognized him immediately, just from what we saw in the media with photos, videos. We just didn't even think twice about it. We knew that was our guy.
Luigi Mangione's highly publicized arrest is the issue in court on Tuesday. A focus on how police approached him and then searched him. Roughly 20 minutes of police body camera footage was shown in the courtroom, showing officers approaching Mangione in that McDonald's. The reading of his warnings pursuant to Miranda versus Arizona, and our Scripps News reporter Alex Miller was inside of the courtroom and described for us this eerie moment during the playing of the footage where you hear Jingle Bell Rock playing inside the McDonald's. And Officer Joseph Detweiler was whistling to it. And that officer told the court that he was just trying to make Mangione think that they were going in on just any other call. Another interesting note about the body camera footage was the Christmas music blaring in the background. And should Luigi Mangione's Miranda statements be excluded? Okay, so this is the issue. Whether he understands his warnings pursuant to that case, whether they're read, and then whether any statements are admissible. So let's go through this. It's almost like a law school problem. I used to love this stuff when I was in law school. Let's bring in Franz Borghardt and Sunny Slaughter and walk through this. Franz, I can just hear my professor in my voice still now. Custody plus interrogation equals Miranda. So you're a professor too, Franz. You do that on the side when you have time and, you know, in your days with your busy law practice. Tell me, where do you think the problem may lie here with Luigi Mangione and whether any statements may need to be excluded?
So I think you hit the nail on the head. It's whether or not he was in custody and whether or not the statements, having been properly advised, were freely and voluntarily given. You know, here's the thing. I can't imagine that there's validity to this, but they're absolutely doing what you do in defending someone. You file the motion to suppress, you try to suppress the statements. The problem is where the rubber meets the road is sometimes defendants or suspects start making voluntary admissions that are not subject to an interrogation. So what did he say? How did he say it? What were the conditions? And if there's body camera footage, we can kind of see the whole thing, right? So he's going to have to prove either that he wasn't advised or that he was in some sort of duress. And you know, look, that optics of the McDonald's eating breakfast, having possibly just killed somebody, all of this is just creepy weird. So it's just, I don't know that he's going to have much of a leg to stand on, but make the government jump through the hoops so that once it is declared constitutional, they can use it.
Right, right, Franz, exactly. Well explained. Sunny, I want to go through with you what the officer said that he did when he was approaching Luigi Mangione and have you assess his actions for us, please. So the same officer, Officer Detweiler, says, I walked by Luigi Mangione at first to see how he would react before approaching him. I then asked Mangione for his name. He responded his name was Mark Rosario. The officer then asked him to pull down his mask, and he said once he pulled down the mask, he knew it was him immediately. Sunny, your thoughts, please.
So, this was good processing of the particular situation. This is situational awareness. It is calming and de-escalating any potential issues. And more importantly, they were looking for a murderer, allegedly, because they knew what this was a national and global bolo. Be on the lookout for this individual. And he wanted to approach it very safely, very calmly in a McDonald's where other people were. This is good policing and good tactical response. So he did what he was supposed to do. Good training, good focus to de-escalate and calm the situation and ensure that he was going to interact with a person that had the potential to murder someone because he just allegedly did it.
Sunny, thank you so much for that. Yeah, I mean, when we think back to what the situation was, America was on edge at the time. I mean, we all were wondering, my goodness, is this assassin, whoever he is, we didn't know an identity, the person who killed Brian Thompson? Are they going to harm someone else? Are they going to continue on this rampage? And so officers have to act so carefully, as you said, so as not to frighten him if it is their guy, you know, or cause him to, become suspicious and pull out his gun first. We knew that this person was armed and dangerous. So happy to hear you say these officers did well with him. So what happens then is, after he discloses his true identity, the officer told him, look, if you're lying, you're going to be, charged with false ID. And, so he eventually says his name, and they then proceed to read him his rights. The officer read him his rights, but added that Mangione was not in custody at this point, and said a compliant Mangione was frisked again and then handcuffed, and I'll Be Home for Christmas was playing in the background. They patted him down. They pushed the backpack away from him for everyone's safety. In the backpack, they found a 9mm handgun, a 3D printed gun. Prosecutors say it matches the one that was used to fire those shots at Brian Thompson. They also found a journal in that backpack that included some writings by Luigi Mangione with his intent to, use his word here, intent to whack a health insurance executive. Mangione is a good attorney. We know, actually a team of very good attorneys. Lead counsel is Karen Agnifilo. She's married to Mark Agnifilo, who was lead counsel for Sean Combs. And she pointed out that the officer said on the body camera footage, at this point, we're probably going to need a search warrant for the backpack. But colleagues of that officer had already rifled through it and found those pieces of evidence, the gun and the journal. Ugh. All right, let's talk about, could they prosecute him without the gun and the journal? Franz, let me go back to you. This is a hot mess, isn't it? You have the statement about not in custody after Red Miranda, going through the backpack and then saying, oh, we might need a warrant, and it's caught on camera. And if these things get excluded, what in the world happens with a prosecution? Franz, go.
Well, so the search of the backpack is a problem for the government. Unlike the statements, there is a problem there, okay? So to oversimplify it, they can absolutely detain him. They absolutely can pat him down, as you know. We call it a stop and frisk. They can absolutely pat him down to make sure he doesn't have any weapons on his person. They can take the bag away from him in case that there is a weapon on his person, but they can't rifle through the bag unless he either gives consent or there's a warrant. Now, if they suppress the search of the bag, it's not just the suppression of the search of the bag, it's suppressing anything that is, quote, the fruit of a poisonous tree, a bad search, unless they would have inevitably discovered the evidence without the search of the bag. It's a lot, right? Long story made short, if they suppress the search of the bag, they might lose the gun unless they would have inevitably discovered the gun anyway. Now, here's the kicker. Most jurisdictions allow for a inventory search of an automobile, not necessarily of bags, subsequent to an arrest. So had they all kept their mouth shut and waited, they might have been able to go into the bag or at least get a warrant. So this is a cluster. I'm not going to use the last word. It's a cluster, and it may create a valid constitutional claim for Luigi.
Professor Franz Borghardt, beautiful analysis.
Yeah.
I agree. It's a cluster. You're absolutely right. It is a legal cluster. And you know what? These defense attorneys, they are so good. I mean, they're picking up on every little nuance, every little possible violation of his rights here. And I wouldn't be surprised if we see some things excluded. Sonny, let's talk a little bit about officer safety. So, dovetailing off of what Franz said, he's exactly right. And I practiced in Pennsylvania where this arrest happened. He's right. If you get a suspect out of a car, you can go ahead and make sure there are no weapons in the car, incident to arrest. You can search as well. Because if there's something readily accessible to where the person stayed, right, they can reach in, grab under the seat, the officer could get hurt. Here he's in the McDonald's. He's sitting down, eating his McMuffin or whatever he's doing. We don't have the car here. As Franz said, they pushed the backpack away from him so it wasn't within reach. This is where it gets tricky. So, I mean, Sonny, the officers, I mean, going in that backpack, your thoughts on what they did?
Franz, 100%. Let me come to class with you, okay? But the backpack is problematic for everything that Franz said, Julie, for everything that you have said. What happens sometimes, this is a high-profile case, and it also happens in cases that are not high-profile. But this particular case, the excitement, the adrenaline of law enforcement in these moments, they kind of can get caught up, and the caught up can be the cluster, in the other word, okay? And that's where we are right now. It is going to be problematic because access and proximity of the bag is where the constitutionality then becomes problematic for the prosecution because he no longer had access. It was away from him, and they should have waited.
Yeah, you're right, Sonny. They should have waited. You know, because there was no urgency at that point. You have him cuffed. He can't get to the bag. You're surrounding him. You see the photographs. Very different situation than had he been pulled out of a car and yeah, this is problematic. This case continues. The judge has not made any ruling yet. We don't know how many days the suppression hearing is going to go, but we're going to continue following it for you here on Court TV. Still ahead here on opening statements, we've got a body language expert coming up to break down the behavior of the former pageant queen, Trinity Pogue, who's now a defendant. Plus,
had she ever told you that she didn't like JD, or that she hated JD, or made any comments like that?
She made comments, but then like maybe a few hours, like she I always treat him like he's mine.
we're taking a closer look into little baby Jackson. They call him JD in the courtroom. His injuries, how he died, and does his father have any responsibility in this? We'll discuss it when we return.
Now, back to the Court TV podcast.
Welcome back. Our spotlight this morning focuses on defendant Trinity Pogue. She's the former Georgia pageant queen. She's looking at possibly life in prison if she's convicted of killing her boyfriend's baby, little 18-month-old baby. His legal name is Romeo Angeles. He's referred to in the courtroom as JD. He's also called Jackson. His dad called him Jackson. This precious child has been through so much. And we're going to be diving deeper into the details around little baby JD's death a little bit later on the show. But right now, we're spotlighting Miss Congeniality here, the former Miss Donaldsonville 2023. Donaldsonville is in Georgia, and she's got many looks, this defendant. There she is in her pageant photos, and she looks different in the courtroom. How much is the jury focused on her and her behaviors? We want to assess that. Let's bring in jury consultant and human behavior expert Susan Constantine to help us do that. Susan, always a pleasure to see you. So I want to show you some videos, and we'll have you kind of talk over them and tell us what you're seeing here. So let's start with one of the pretrial hearings, because this one got a lot of people talking, because the photos of the pageant work had circulated when she was charged, and then she comes to court and you see this look right here.
So what we're looking at here, Julie, is that you can see her kind of gulping. So there's a fear response here, but what she's doing is what we call a controlled temperance. So she is trying to give off the expression of that it is not serious, that it's more of a neutral expression. So this is what we call the controlled temperance. So this is used for a strategic advantage, is not to show any emotions, but it actually shows emotion, because no emotion also sends a message to the jury that she's not taking it seriously. She's got rapid eye blinking, so we've got some cognitive load, some gulping and swallowing, which can be fear responses. But let's not also eliminate the angry brow look. So when we look at the angry bird look, I call it the angry brow bird look, and you. Yeah, so we see this, if we look at this and compare it to her other photos where she's very bright and she's very vibrant, there is a change in the demeanor, change in attitude, change in emotions, change in feelings.
Yeah, let's look at those photos. So here are the pageant photos. Now, granted, I would imagine there's some retouching on the professional photos. There always are. Every headshot I've ever taken in television news and gosh, all the years I've been in this business, they're always retouched when they're professionally done. So there's that. But this is video. Susan, what do you think of the expressions you see here?
Okay, well, when we look at this expression here, first of all, she's in performance. We know that. Hands on the hip, and she does a little pop where she kind of pops out. And we see a lot of models will do it's kind of like that little kickstart and this little swagger. This one right here, she just kind of walks out and sort of shuffles her way through it. But she has what we call a Duchenne smile. This is what we call a cordial smile. This is not a felt smile. This is one that says, okay, I'm in performance, now smile. And that's what she does. So she's doing it on cue. Her hand, even her movements, they're not really swaying in a natural rhythm. They're more at her side. So again, here's these very controlled movements. But she knows that everybody's looking at her. So she's adjusting her behavior, her walk, her posture, etc.
She just seems to be exuding confidence to me, Susan. When I look at her, especially in the white, beautiful gown and then the short black cocktail dress, I just feel like she has tons of confidence. Are you reading that? I mean, you're the expert on body language, not me.
Well, when we look at confidence, usually body language spreads out, right? So you expand. She doesn't expand. So yes, she's being confident. She likes herself. She feels good about herself, but it's still in performance, Julie. So she doesn't have this natural rhythm. It's more of a swag. Now right there, that's confidence. That's the confidence that I'm talking about. Okay, let's just throw that hip out there, throw that hand on the hips, and let's do a little swag. That's when saying, yeah, I'm hot. I know it.
Yes. In that little moment, exactly. I'm seeing it.
Yes.
Work it, girl. Yeah, I mean, she definitely has it there. In the courtroom, does she have the confidence? Don't know. Susan, when this trial kicked off on Tuesday and her defense counsel was delivering his opening statement, take a look at what she was doing.
Sure. So, I mean, we're seeing a lot of grooming gestures. Her hair is down around her face. So, there's emotion there, because you can see where the cheeks are a little bit more flushed, the nose is a little bit more flushed. So I'm sure that she does have emotion. I do think they did a good job in putting in her blush color, softening her hair up. However, when you look at it in its whole totality, they're looking at her dabbing, her tears, but is she actually flowing with tears? No, these are what we call crocodile tears. And so, yes, they're real, but they're not what we call an emotion that is at a higher intensity. They're in a low intensity. But we're looking at some other ones in here. Now she's biting her lip. This is uncertainty, concern, rapid eye blinking, looking down. This is someone that's kind of detaching. They're in what we call a kinesthetic mode. They're processing emotion. She's looking up at the jury and she's looking around, but she's kind of scattered around because she's got a lot of emotions that's going through her head. So we can look at everything. In fact, when I'm analyzing video, do you know that just 1 minute of video takes about an hour and 10 minutes when you really break down every single muscle in the face, and it can reveal what she's actually thinking and feeling.
Wow, that's fascinating stuff. Susan Constantine, we love having you on the show. Excellent analysis as always. See you soon. We're going to hit a break, but we're not done talking about this case. When we come back, we're talking about this beautiful little baby JD, and his injuries. Could his dad be responsible? Well, the defense team sure thinks so. We'll talk about that. Plus, live look at the courtroom in Massachusetts. The trial for Brian Walshe set to get underway in minutes.
This is the Court TV podcast.
Initially, I told him I didn't know he was with my girlfriend. Then when my girlfriend got there, well, when she got there, she said he fell off a chair.
The baby fell off the chair, off the bed. Who knows? There was a baby beaten to death, maybe? Let's talk about this case. So Trinity Pogue is on trial, and the biological father of that precious 18-month-old baby, JD, took the stand on Tuesday. So he was Trinity Pogue's boyfriend, and his child was found unresponsive in Trinity Pogue's dorm room when she was going to school at Georgia Southwestern State University. This happened in January of 2024. This precious 18-month-old child died at a local hospital after he was rushed there when Dad went to go get pizza, and something happened in the dorm room, according to prosecutors. This is some video of him playing. Look at his baby bottle. See how it's green there? Yeah, that's Mountain Dew. They were giving this baby to drink. The baby died by blunt force trauma to his head and his torso, according to the medical examiner. He had fatal brain damage, as well as a laceration to his liver. Julian Williams, the boy's dad, was asked about his son's injuries when he took the stand.
Who was Romeo Angeles?
It's my son. She gave him some Mountain Dew and like a Frito Dorito. It's Frito, like the barbecue twister chips. Okay. And he was sitting there eating them. She had him in her hands. It's like he's limp. I don't know what happened. So I threw the pizza, dropped it, and grabbed him and took off.
The defense also pointed out that there was blood in the baby's stool, indicating that there was something wrong prior to the incident in question. So is the defense team trying to pin this on the baby's dad? Let's bring back in attorney Franz Borghardt and welcome in board-certified forensic pathologist Dr. Priya Banerjee. So Franz, starting with the question of the defense, do you think they're trying to blame this on Dad? And might Dad be responsible here?
I think they kind of have to pin it on Dad if they're not going the route of she snapped and this isn't like the worst murder. It's something less because she snapped, and that people sometimes snapped in stressful situations. That said, I watched him testify yesterday, Julie. I thought he did a great job. He comes across, look, giving a kid Mountain Dew is not standard operating procedure in my household. But in the same breath, there is a far cry between that and beating a child to death. And I got the impression through his testimony, he genuinely cared about this child. He tried to be there as much as he could for this child. There was some co-parenting that was going on. I liked him as a witness. He may not win Father of the Year, but I think a lot of jurors who have kids are going to say, you know what, sometimes, you know, you do things that are unconventional because that's what parenting sometimes means. And I think he's likable. I think a jury's going to like him. So the pointing the finger at him, I think, is going to ultimately fail. But that may be the best route they have, Julie.
Sure. Great points, Franz. Dr. Priya Banerjee, let me go to you, please, on JD's injuries. So we know this precious child had very bad trauma to his head, to his torso, bleeding on the brain, bruising on his face. And we know we're looking at a very short window of time that Dad's eyes weren't on him, just the 20 minutes or so that's estimated that it took for him to go get the pizza and come back to the dorm. What do you think? Do you think that's enough time for this child to sustain such bad injuries?
Yes. So this falling from a chair, or the story keeps changing, is just inconsistent with the severity of these injuries. Babies, toddlers that size are bouncy. You know, as a mom myself, kids can get bruises on their shins, moving around. We saw him playing. But this level of head injury and liver laceration with bleeding, or liver injury, it's inconsistent and doesn't even make sense. I know they're looking for an alternate. And yes, that time frame is short enough to really, if a lot of force is used to beat him and she's with them, that's not looking good for her.
Right. Dr. Priya, I have a couple follow-up questions for you, please. The defense team is saying that baby JD's skull wasn't fully formed at 18 months of age, and that his organs then would have been more susceptible to injury because of his age. Those things true?
I don't believe that to be the case. I think kids that size, I shouldn't call him a baby, but a toddler that size is very bouncy and less susceptible to injury. It takes a lot of force. If you think about it, toddler bellies stick out, they fall, they're bumping all over, learning to walk, run, or already there. That should not affect his abdominal injuries, and his head is still growing, right? So our brains grow until 2 years of age. So the skull has what's called sutures, right? Those soft spots. The skull's not completely fused, but that also doesn't make it more susceptible to injury. That's a normal separation of the skull bones that ultimately will fuse. So neither of these make logical sense. That's how we develop. If the skull closes too early, then our brains can't form appropriately. That's actually a separate medical condition. So none of these explanations make sense.
Right. This is really interesting, Dr. Priya. So what makes sense to the prosecution is that Trinity Pogue resented taking care of this baby. It was not her baby. She's 18. Doesn't seem like making the best decisions, going to the vending machine, presumably, to give him barbecue Fritos. Franz, tell me, how strong do you think the prosecution's theory is that she was the one and the only one in the dorm room with the baby who could have hurt him so badly?
So I think it's a good, strong case. And I think they have the makings of a motive, as you know, and as the viewers probably know. You don't need a motive, but you kind of have a subtle, like, this is not my kid. I love him. Why am I having to care for this kid? You've got the makings of a motive. And so I do think it's a good case. I do think that she also presents very poorly as a defendant, in the sense of, you know, the whole pageant thing, her in-court demeanor. So I think it is a good, strong case. It's not an airtight case. There are defenses to it, and I certainly hope they have an expert to back up some of their medical contentions.
Really great points. We'll leave it there for now. We're going to be covering this case intensely throughout the day, today on Court TV Live. Franz Borghardt, Dr. Priya Banerjee, thank you very much for the great analysis.
That's all for this episode of Opening Statements, my friends. I'm your host, Julie Grant, and it's been great being with you. On this show, I am calling out any pants on fire moments in our big trials and true crime stories, and I want you to come along with me. Opening Statements is live every weekday morning at 8 a.m. Eastern on Court TV. Thank you for downloading this episode. Please subscribe, leave a review, and share it with your friends. You can watch past shows anytime you like on CourtTV.com.